The next case is County of San Diego Department of Child Support Services versus CA on page 4 of your materials. Now, our lives in family law are getting harder because so many cases now keep the names of the parties confidential, and so a lot of published family law cases are now either called by the parties' initials or, as in this case, the parties are just mother and father. I'm sorry, but it's just going to get harder and harder to remember the names of important cases, but if it's any consolation, there are no important cases this year. In this case, mother and father married, they had a child, they divorced in Hawaii. The judgment gives joint legal custody to both of them, but the father has physical custody of the child, and mom is ordered to pay $70 a month in child support. They all moved to California, but then dad ups and moves with the child to Maryland to go live with his mother in Maryland. That's grandma. And quickly enough, grandma becomes the child's primary caregiver. But grandma didn't just do this informally. In 2012, she files a complaint in Maryland seeking sole legal and physical custody of the grandchild and asks that both mother and father pay child support to grandma. And grandma also enrolled the Hawaii divorce judgment in Maryland and got the Maryland court to modify the Hawaii judgment to give her sole legal and physical custody. Father consents to a $310 a month child support order and mother defaults. So the state of Maryland sends its request for child support to the San Diego Department of Child Support Services, that's DCSS, to get a support order against mother. And the trial court says, well, there's no agreement between mother and grandmother to pay grandma for taking care of the child. And we have Family Code 3951. Subpart A, which says a parent is not bound to compensate the other parent or a relative for the voluntary support of the parent's child without an agreement for compensation. Trial court says, hey, grandma took on this kid voluntarily, and grandma loses. Well, DCSS says, we're appealing. Court of Appeal reverses and says, if this were an informal family arrangement for grandma to parent the child, then mom would be right. She couldn't be made to contribute financially. But when grandma got actual legal and physical custody of the child, she's no longer just voluntarily, voluntarily supporting her grandchild. She may have started as a volunteer, but now she is somebody with real rights, obligations, and duties and responsibilities that go forward indefinitely. Mom is simply one more non-custodial parent who gets to pay child support to grandma. And this is a case where neither parent's parental rights had actually been terminated, so they're both still on the hook. This case is actually good for counseling parties where neither parent can take care of their kids and a relative or friend needs to step up. There are implications for not dealing with such a case informally. Bob?
Greiner versus Keller is at page 5 of your materials, if you have materials. Mom, working part-time as a receptionist and also receiving public assistance, signs up for a paralegal class and asks Dad to pay 1/2 of the extra child care she's going to incur. Evaluating Family Code Section 4062, the trial court says where Mom is employed and already has marketable skills and is merely trying to expand those skills, that exceeds the scope of what the statute requires. Her request is denied. But the Court of Appeal reverses. As this is a statutory interpretation, an issue of law, they give independent review. They note courts may not add qualifying conditions to a statute under the guise of interpretation, and this statute does not have the limitation imposed by the trial court. Further, they point out the legislature has explicitly stated as a goal that the needs of children should be met as much as possible through the private financial resources rather than public assistance. Mom testified that not needing public assistance at all was the goal of her seeking this training. And that was the way the Court of Appeal distinguished this case from the marriage of Kara and Samir. In that case, the parties agreed to split the cost of mom's obtaining a master's degree of social work. But when she wanted to go on for a doctorate, the court denied further contribution to the child care needed for her elective education, as she was able to be fully self-supporting without public assistance, but she chose not to work. Jim.
Okay, the next case is SC, not the college, versus GS. Here the father was ordered to pay child support, and from 1998 to 2005, he was incarcerated. Now, a lot of you are probably going to say, I'm never going to have a client as a con or an ex-con, but keep in mind, I know I've had a few back in my practice as well as on the bench. So, be aware that that does happen to all of us. Well, here in 2015, the Department of Child Support Services brings an action to increase the child support, and also they're seeking their monthly payment on the arrears. And they contended the arrears now were up to $114,000. The trial court then ordered them to delete the amount of time that the party was incarcerated, and that dropped it down to $40,747. So under 3601, and there's a different analysis here than what Bob had. 3601 provides that child support continues in effect until it is modified by court order or by operational law. Support can be modified under 3603 except to the amounts that have been accrued. Also under 3692, it's clear that the accrued support cannot be set aside because the court finds it's inequitable when the order was made, or because of subsequent circumstances that make it excessive or inadequate. Taken together, the court lacks discretion to absolve an obligor of an accrued support obligation. 290 gives the court broad discretion, but that is how to enforce the order, not to make the order. So they can do it by execution, contempt, or even appointing a receiver. However, that discretion does not allow the court to ignore the statutory requirements not to absolve the obligor of the obligation. And of course, there was 4007.5, and Bob has already gone into that it was in effect, but it applied, number one, to only orders made after it went into effect in July 2011, and hasn't had any other provision to keep it in effect any longer. So in this case particularly, it had no effect whatsoever.
The next case is County of Los Angeles Child Support Services Division versus Watson at page 7. The Los Angeles CSSD files thousands of cases, mostly against unmarried guys, seeking to establish child support judgments every year. There are statutes designed to make the process efficient and relatively easy for CSSD. Family Code Section 17430A says CSSD can get child support judgments without a hearing or further notice to defendants once 30 days have passed after the defendant is served with a summons and complaint and proposed judgment, and the defendant doesn't file an answer or other response. Well, huge numbers of defendants, like the defendant in this case, just default every year. But there's a different statute that governs whether a child support order, whether sought by a child support agency in a support action or a parent in a family law case, may be retroactive to the date of the filing of the complaint or petition, and that is Family Code 4009, which provides an original order for child support may be made retroactive to the date of filing the petition or complaint, but if the parent ordered to pay support was not served with the petition or complaint, or whatever it was, within 90 days after filing, and the court finds that the parent was not intentionally evading service, the child support order shall be effective no earlier than the date of service. So in this case, Mr. Watson is such a defendant, but he wasn't served until 96 days after the complaint against him was filed. Watson defaulted, DCSS submits the proposed judgment for rubber stamping by the Child Support Commissioner. And if that had happened, the support order would have started December 1st, 2017. But here the commissioner stamps the proposed judgment with a rubber stamp that said, quote, child support commencement date pursuant to Family Code Section 4009, unquote, and made the start date March 1st of 2018. So DCSS appeals, and by God, the Court of Appeal reverses. It held that Family Code Section 4009 contains a requirement that the court has to be able to find that the defendant wasn't trying to avoid service. Well, there's no evidence of this. Mr. Watson isn't there. He's defaulted. CSSD has no duty to put up any evidence to show that this guy was or wasn't trying to evade service. And a rubber stamp on a judgment isn't going to do it. So the upshot is the court is not able to make a finding that the defendant wasn't trying to evade service, and this judgment needs to be entered on December 1st, 2017, which means, in effect, if you default, you are going to lose. You get no protection, even if CSSD sits on the complaint for months and months and months and just never gets it served.